I'm Steve Sanders. I'm Associate Professor of Law at Indiana University Maurer School of Law in Bloomington. I think one of the things I was really struck by in listening to the oral arguments in the marriage equality cases was sort of how dreary they were, how unexciting, how unsexy in many ways. It really did seem like the justices, both the conservatives and the liberals, were reaching for a way to avoid having to take on the central issues in those cases. What do the Equal Protection Clause and the Due Process clauses mean for gays and lesbians? What do they mean for marriage equality? This many years after Loving versus Virginia, why are we still groping around in the dark as to what the contours are of the fundamental right to marry as provided in the Constitution? So, assuming that the court does not settle the meaning of marriage, same-sex marriage for the entire country, assuming the court doesn't give us a substantive understanding of the meaning of equal protection or due process for same-sex couples in these cases, I have some thoughts about what the next wave of marriage equality litigation should look like. I think we actually have two marriage equality problems in this country the Constitution needs to address. One is the right of same-sex couples to get married. The other is the right of same-sex couples to remain married. We already have tens of thousands of legally married same-sex couples in the 12 states plus the District of Columbia where marriage is legal, and we know from demographic data that thousands of those couples will change states every year. Well, 36 states still purport to actually void those marriages, to deny them legal recognition. I think that's a problem. I think that's even more offensive than being prohibited from marrying the person you love. Those people have acquired vested rights and expectation interests in the ongoing nature of their marriage. And so I focused a lot of my writing about how when you get a valid marriage from a state that's willing to give you one, you acquire a liberty interest in the ongoing existence of that marriage that the state can't take away. And if a state asserts interests in privileging heterosexual marriage, those interests have to be weighed against the interests of a couple that is having something real and tangible taken away from them. When they're not denied the right to get married, they're having a marriage actually taken away from them. I think that's a problem. I would like to see the national civil rights and gay lesbian organizations take on that problem because I think it would make a very sympathetic case for litigation. The other place I think federal litigation needs to focus is taking account of the difference between mini-DOMAs, laws that prohibit same-sex marriage, that are merely statutory and those that are embedded in constitutional amendments. Our friends in the Federalist Society, people like Justice Scalia, tell us we should use the legislatures for social change, not the courts. Marriage equality is now commanding a majority in many nationwide polls. So maybe marriage equality could win in a fair fight. The problem is in 30 of those 36 states, it's not a fair fight because marriage discrimination has been placed in those states' constitutions. It's been placed above ordinary politics, beyond the reach of 50% plus one of a legislature. We have what the constitutional theorist John Hart Ely called stoppages in the political process in those cases. There's a long-standing and very noble understanding of the Equal Protection Clause that says when the political process has been gummed up or rigged against the interests of a particular minority group so that that group can't use the ordinary political process to vindicate its interests, that is when judicial intervention and judicial review is most democratically appropriate. I think that's the problem we have right now with the mini-DOMAs that are embedded in state constitutions. You have states where there's actually majority support for marriage equality in some cases, yet the state constitution prevents the legislature or even that state's courts from revisiting the question and actually vindicating what the public in those states actually wants. So I think there definitely is an agenda for marriage litigation, after Perry, and these are two of the issues that litigators ought to be thinking about and framing their cases around.